Hello, everyone. A very good afternoon to you, and welcome to this webinar, which is curated with an in-house lawyer in mind. I recognize the presence of our main speakers and panelists who will be introduced to you shortly during the course of the webinar. My name is Gloria Tendera, and I'm the chairperson of the ELS in-house committee lawyers, and I will be your host today. ELS is keen on creating impactful learning and a sharing environment. And I dare say we have plenty in store for you today. Today, we get to discuss topics that create and elevate our sense of awareness, all with a view of highlighting the theme of this topic, of this webinar, which is creating visibility and influence in order to be effective as an in-house lawyer. I like to quote John Maxwell, who is a renowned leadership expert, who calls this the law of the lead. And I paraphrase. He says that we can never operate on a level of higher than our abilities. So meaning that if your ability on a scale of 1 to 10 is a 4, you can never be more effective, or you'll never go beyond the level of 3. This webinar aims to tackle this. The first part will feature the speakers who have prepared learning points for us. And the second part will be a Q&A session. I encourage you to use the channels, the chat channels, and the Q&A to raise your questions.
Oh, I already sent them a message.
To raise your questions so that we can have an interactive webinar. Here to co-host with me is Hope Kisitu Atuhaire, who is the vice chairperson of the in-house lawyers committee. To start us off, I would like to invite the president of the ELS to give us his opening remarks. You're welcome, President.
Thank you, Gloria. A warm welcome to all East Africa Law Society members to this webinar on in-house lawyers. And I would like to take this opportunity on behalf of the East Africa Law Society to thank the panelists, especially my Lord Justice Kiawire and all the other panelists. Thank you so much for always coming to share with the East Africa Law Society. We are always proud to have you. And I know that this session is going to be a very good session for in-house lawyers. I'm also looking forward to it, to learn from our panelists and be able to share experiences. Thank you so much, and a welcome to you all. Thank you so much, Gloria.
Thank you, President. I would like to point out that we are running a survey on topics of interest that you might be interested in to be trained on. So take a few minutes to record your ideas in the chat box. And also, if not, you can also fill in the survey at the end of the webinar. So to quickly start off this webinar, I invite the co-host, Hope, to introduce the first two speakers of this webinar. Hope, please proceed. Hope, are you with us?
Thank you, Gloria. And as introduced, my name is Hope Atuhaire Kisitu, and it is indeed my pleasure to introduce our first speaker this afternoon, and that is Dr. James Moria, the Group Chief Executive Officer and Managing Director of Centum Investment Company Limited. Dr. Moria has held this position since October 2008. Dr. Moria serves on several boards, including those of Sidian Bank Limited and Almasi Beverages Limited, where he serves as chairman. He's also a director at Nairobi Bottlers Limited, Isuzu East Africa Limited, Investment Holdings Limited, Centum Exotics Limited, among others. He's also appointed as Chancellor of Machakos University. He's been appointed Chancellor of Machakos University since October 2016. Dr. Moria holds a Bachelor of Laws degree from the University of Nairobi and a doctorate in business an honorary doctorate in business from Machakos University. He's an advocate of the High Court of Kenya, a chartered financial analyst, a chartered global management accountant, a fellow of the Kenyan Institute of Management, and a member of the Institute of Certified Public Accountants of Kenya. Dr. Moria will be speaking to us this afternoon about leadership. And now I invite him to actually make his address. Dr. Moria, karibuni sana.
Thank you very much, Hope, for that very eloquent introduction. The President of the East Africa Law Society, distinguished guests, fellow panelists, it's really my pleasure to join you this afternoon. I received this invitation with great interest last week. It came from an old friend of mine who served for a long time as an in-house lawyer, A.K. Maina, and he subsequently served as the managing director of Kenya Railways. So it's just testament to what in-house lawyers can achieve. So it's a pleasure for me to be with you this afternoon and to share with you some of my experiences on the leadership journey. And as you've heard from Hope, my background is as a lawyer, and I was admitted as an advocate in 2003, so about 18 years ago. Indeed, I did not join the organization as CEO. I joined further down the ranks, and perhaps I will want to share with you some of my experiences. I understand today we're engaging with in-house lawyers who are serving either as company secretaries or in-house counsel of different corporates. So I'll make my remarks in that context. That's the context of the audience. I think for you to plug into leadership of any organization, the most important thing, first and foremost, is to understand your client. Your client is the company that you serve. To understand who they are, what their background is, what their vision is, but then also what is their strategy? How do they make money? How do they create value? And then figure out how you can then play an integral role in that process rather than merely a supportive role. I recall in my first year of joining the organization, I sat down at the end of the year and asked myself, and I did an audit of everything that I had done for the organization, and I asked myself, if I had not been in this organization and I had not done these things, what impact would that have had on the profit and loss of the organization? Yes, I'd been very busy. Part of my role was taking minutes. Part of it was handling various legal matters. But then the question I asked myself, where on the P&L do I play? P&L is a profit and loss. Do I see my contribution in revenue? Do I see it in saving costs? Do I see it in opportunities that I've brought onto the table? Do I see it in risks that we have mitigated? And it's when I started asking myself that question that I then said, and frankly speaking, that first year, there was no direct correlation between what I was doing and the P&L. And the subject is leadership. It's about elevating the profession and elevating yourself so that then you can be integral to the operations of the organization and you can help drive it. One can obviously always choose to sort of be a peripheral player, but the subject is how do you move from the periphery to the center. And it then required me to then really understand the business and understand where the opportunities are, where the risks are, and how can I then spend 80% of my time on activities that have a bearing to commercial outcomes that are important to the organization, and perhaps focus on delegating or outsourcing the 20% that do not have a direct bearing. Sometimes many of us in the profession do not take this into consideration. So we end up outsourcing what is core and insourcing what may be largely as a support function. But also understanding that the law is not an end in itself. When you're working for your client, it's a means to an end. So it's about finding solutions for your client, in this case, the companies we all serve, helping the companies better manage risks within the context of the law. I recall early on, we had a legal manager, and a lot of transactions were stalling at their desk because the law had become an impediment. The law does not allow this, the law does not allow this, but you're in the business of finding solutions within the law. And I'm pleased to say I've served as the CEO of my organization. I'm now on my 13th year, and we don't have a single lawsuit outstanding or not been sued by anybody, neither have we sued. Not to say we've not had disputes, not to say we've not had challenges, but it's sort of using the law as a tool, as an instrument to resolve issues, and not necessarily, sort of not necessarily resulting to lawsuits, but sort of using appropriate tools to address the business of the company. And up until that time, sort of going the lawsuit way has not been appropriate for us. So with the benefit of my legal background, one is able to make those decisions and determinations and sort of see the best way of resolving issues. Now, I know I'm speaking to, there are many company secretaries in the audience, and they may be asking themselves, I attend board meetings, I sit next to the chairman or next to the CEO, I take minutes. Rarely does anyone ask my opinion. How do I raise my visibility and influence in my organization? Indeed, the theme of today's conference is creating visibility and influence for effectiveness. And I wanted to speak to company secretaries first and then speak to legal counsels next with some specific ideas. One, I think company secretaries potentially play a very important role, and they can potentially play a very critical role to the success of any organization and to the success of an effective board. But to do so as a company secretary, you must understand the strategy and the business of your company. You must understand what is important, what will move the needle, what decisions are very, very critical, what does the board need to have oversight of. I've had the privilege of sitting in boards of many companies in my career, and I've served in boards where we had effective secretaries, and I've served in boards where we had ineffective secretaries. Boards where we had effective secretaries, the agenda was such that the board ended up spending a lot of its time deliberating on matters where, if decisions are made, will have a significant impact on the outcome of the business of the company. In boards that were less effective, it was all mixed up. Some issues were important, some issues were not as important, some issues did not have as much impact, some issues were more of a managerial issues, and sometimes there was no coherence between the board work plan and the strategy of the business. So the second thing is that it's important to tailor the board work plan and the work plan of the committees. By work plan, I mean, what will boards discuss, because typically boards have quarterly meetings. What will they discuss in the various quarters, aligned to the annual operating plan of the organization, so that then the board work plan is proactive. It's sort of forward-looking as opposed to reactive, because there's an expectation based on the operating plan of the business, which has been presented to the board of the company to approve. Where will the business be by that quarter? And that then informs your agenda, not just for the board, but also for the committees. The third thing is then to ensure that the substance of what is coming to the board are board level issues. When you look at the business, what is critical? what is driving, what is moving the needle, but then also ensuring that the board papers have sufficient information to enable a reasonable board member, a reasonably competent board member to make a decision in that meeting. There are too many meetings that are bought or that do not complete because the papers come incomplete. Many times we blame management for that, but an effective company secretary can play a role so that their role is not just posting the papers on either a tool where I had this conversation around technology. It's not just about posting the papers on the tool or sending the papers to the members. It's making sure that you've received them in a timely fashion. You've engaged with the management early enough on the issue so that you get the papers in good time. You've read them. They are succinct. The key issues are clear, and the key decisions that need to be made are also clear. The other fourth point is just clarity on what decisions need to be made to enable management to move forward. Effective meetings, there's clarity at the onset what approvals and decisions management is looking for in a particular meeting. And there's clarity when you look at the papers, what is expected of you, because that then enables your board to focus on what is there for information and what is there for decision, to ensure that you do not miss a meeting where a decision is brought to the board and the matter is deferred because either the information was insufficient or the board members were not properly appraised. That deferral costs your organization, and you miss the opportunity as a company secretary to be more effective. The fifth thing is, if the decisions are clear and you've engaged with your chairman ahead of time, so that he or she goes through the agenda, there's clarity what decisions are expected of the board, and you help in getting the decision. Clarity of the minutes is very important. Many times you see minutes that are very detailed, but they miss what the decision was and the rationale of the decision. And that is because many times you make a decision as a board and things don't pan out as expected, and you go back to the minutes to sort of get a sense of what was the circumstances or the background against which this decision was made. And the minutes are not clear. And they're not clear what changed. And so a lot of the core substance is missed. So when you have succession planning in boards and new board members come in, it's not clear what informed prior decisions, what assumptions were made, because that then informs the risk management side of things, because boards make decisions in the context of certain assumptions. So the clarity of the minutes is very important. So it's sort of elevating what is taken as a fairly mundane craft, minute taking, to really making it sort of a tool of sort of providing clarity what the decision is, what is expected, what are the assumptions that have underpinned that decision, and even where there's objection, what were the grounds for the objection. The sixth issue is that many times you have meetings taking place and there's no clear action plan arising out of that board meeting. And this is an opportunity for the company secretary, those of us who are serving as company secretaries, to generate a very clear action plan coming out of every meeting to be sent to the members of management, as opposed to waiting to sort of 2-3 weeks to the meeting to sort of start asking where we are on matters arising. Because the purpose of a meeting is to generate direction for management to move on for the next quarter. So that ability to generate the clear action plan immediately after a meeting within, say, 24 to 48 hours is critical. But then that's not enough. One then needs to follow up with management on the implementation of the action plan. So many of you company secretaries may be sitting in your ExCos. And when you sit in that ExCo, it may not be clear where exactly you're adding value. You're adding critical value, particularly when you keep management faithful to what they have committed to the board. And you can really help the CEOs, because the assumption is that the CEO will do that work. But the CEO expects the company secretary to effectively manage the board and the follow-ups with board members and with members of management on closing out critical issues that the board has raised. I think for me, the eighth issue, which is important, is then regularly updating the board on progress being made in the implementation of their decisions, as opposed to waiting for the next meeting. because what that does, that then it closes the information gap, so that when you meet in the next quarter, you sort of are on the same page with your board. The ninth issue is we really need to do our homework on the law and the regulations, because the board expects us to guide them. And I think the board meeting may not be the forum to object, because then you have sight of the papers, you have adequate opportunity to input to your CEO, to your colleagues on the board, what is the legal and regulatory implication of some of the decisions that they're seeking to make, and therefore sort of being proactive in that sense. So it is about how do you elevate the role of the company secretary from one of minute taking and really sort of convening the meeting, the administrative side of it, to bring it to the heart of the strategy of the business, and to make the company secretary an effective partner of the CEO of the company, the chairman, and other board members, where the company secretary is really playing an integral role. And indeed, it's my submission that there's significant scope and opportunity for in-house lawyers to demonstrate leadership in this particular area. I want to move on to those of us who are serving as legal counsels. I've had opportunity to act in this capacity in the past. I've also had the privilege to work with both internal and external counsel on many transactions, and I've observed legal counsel, both who are acting for me and those who are acting for our counterparties. I think the critical first step that many of us miss is understanding the commercial rationale of the transaction. What is it that we are trying to achieve? And what is important? Is it the timeliness of the transaction? Is that what is critical? Is it risk mitigation on my side, that I would rather take time to be extremely careful? Is it, am I in it because the principles in it mainly because they're looking for quick closure so that they can unlock certain funding? It's very important that you understand that. And it's also very important that you understand and you're able to advise what are the legal and regulatory risks arising out of a particular transaction, and you document them and you walk your principles through them, so that having understood the risks, they can then give you the prioritization. Because you don't want to make that decision for them when you're negotiating with your counterparties, having not understood what is critical for the other party. I'll give you an example. At one point, we were a consortium of investors, and we were exiting one of our portfolio companies. It was then decided that the vendors, who was us selling shareholders, would then work on a common term sheet and common legal documents, so that then we could sign with the purchasers. As it would be, the issue for us was speed of conclusion of the transaction. Because of various changes in the market, there was a risk that they may have had a material impact on the performance of the company that was the subject of the transaction, and therefore end up affect the end valuation. So for me, who was a principal there, speed to conclusion was of essence. Issues like warranties and indemnities arising post-transaction were to me secondary. But because we were more aligned with our legal team, we were able to prioritize what was important to us. Now, the legal teams that did not understand that for their clients then put forward issues of warranties and indemnities, which then meant we ended up closing our bid first, and we sold our shares, and we left the other parties still negotiating. These risks did crystallize, and they ended up selling the asset at a significantly lower value than we did. And remember, we're all equally exposed to the same warranties and indemnities. So having clarity so that you're not arguing on legal points, but you're understanding the law to then be able to do a clear matrix and then get the authority of your client, having understood what is critical to them, then to understand what you can give and take so that you can achieve their objectives. So I think that is critical. It's also important that you're on the same page, especially when there are many parties on one side, to generate a document which sets out the objectives as you understand and sets out the risks as you've understood them. So that then they can rank and you have clarity and a document you can refer to during negotiation, because not all points are equally important for your client. Some points you can give in if that is critical. Some points you may not give in, depending on the guidance you've received from the principal. Sometimes this is not clear to us and we rush into various transactions. And you end up not necessarily achieving the outcomes that your client is seeking. I think understanding that and then understanding what is core, so that in the various organizations we sit in, we are not procurement. We don't move from being legal counsel to procurement officers of legal services, because you need to make sure that you are directly escalating the solution on what is critical for your solution, for your organization in their strategy, and you're a subject matter expert on what is critical. You have examples of in-house counsel who are not subject matter experts on what is critical for their organization. They're subject matter experts on routine issues, and on what is critical, they outsource. Now, it is difficult in that kind of arrangement to escalate the visibility of the function, because then it is not a critical function. And the risk you run as a department is that it is easy to outsource that department if it is then not core to what the business is doing. The other point I wanted to make is, once that is done, then it's one thing to generate documents. It's another thing to generate minutes. It's one thing to advise. But what is critical is being able to make things happen. And things happen, transactions close, approvals are granted, disputes are resolved, bottlenecks are unlocked in the real world. And they're unlocked by parties who are external to the organization. So there's external stakeholders. It's very important that in your business, you have a clear map of who are the critical stakeholders in your business, who are external to you. And it's important that you proactively forge a relationship with them, so that you're not going to them when you have a problem, but also that you understand how they see things. For example, if you are in a regulated entity or a business, it's important to understand who your regulators are, who your counterparties are, and forums such as this, as ELS, give you that opportunity to network, but then to also to understand how they understand the regulations, so that as you're understanding the client, you understand how the law is written and then also how the law is applied. And at the end of the day, you're talking to a human being on the other side of the table. So being able to do that is important, because ultimately you'll be more effective in making things happen for your organization. And the more critical you are in making things happen, the greater the visibility and importance this role assumes in your organization. So on the subject of visibility, which is one I'm coming to last, visibility is not useful if it's not backed up by substance and real value add. You need the value add first, then work on the visibility. And the visibility is to ensure that the legal function is part of the core business. When you look at your work plan for the year, how is it aligned in enabling the core business of the organization? The party that is enabling that core business, if then they are the external counsel, those are the people who have visibility. Those are the people who are important to your CEO and to your board. And you really need to plug into the core business and be part and parcel of it. Then ensure that the function is an enabler and an escalator of solutions, rather than just pointing out where the problems are, because there are many ways of doing it. The one way of saying these are the problems, but another thing of saying these are the potential problems and these are the solutions, and then actually going and negotiating and bringing those solutions on the table. Solutions that are aligned to the commercial and strategic objectives of the organizations that you serve. The third issue is you as the in-house legal counsel really taking a real lead role in providing the solution. You have instances where you have effective legal counsel who take significant burden away from their CEO in taking a lead in critical negotiations, resolving disputes, resolving challenges with the regulators. You're out there negotiating. There are others who only advise the CEO to then go and negotiate. So you're just adding to the burden of those that you work with. But there's an opportunity for us to take a lead role in this area. And of course, being proactive by having knowledge. And I think Gloria spoke about knowledge. You know, you cannot substitute enthusiasm for knowledge. Enthusiasm enables knowledge. And the profession we've chosen is one that calls for deep knowledge and expertise. So being really proactive, understanding, but also understanding what are the potential laws and regulations that may have an impact on your business. And being able to understand your business as well, so that you can input and influence the eventual outcome, because laws and regulations have a significant impact on the external operating environment and the performance of the business. You know, that is something very, very important. So I want to conclude by saying that, you know, in-house lawyers have a critical role to play in the leadership of organizations. Leadership is not one person. Leadership is typically a team. So you'll see a successful organization. It's not one person. It's a chairman. It's a CEO. It's a core group. And one, as an in-house lawyer, you have an opportunity to be part of that core group, because you occupy a very, very special place, especially in our environment, where the legal and regulatory environment has a very significant impact on strategic outcomes. So you play a critical role. Many of you occupy very strategic positions, whether you are serving as company secretary, whether you are serving as a director of legal, risk, compliance. Those positions are not support functions. Those functions are actually core and integral to the operations of your business. You have a responsibility of providing leadership also to external counsel, so that you can give them the necessary guidance, but then also motivate them in terms of how you engage with them, so that they don't just give you what you're paying for, but they give you more than you're paying for because of the relationship you've cultivated with them, but also having a good external stakeholder management, sort of external affairs management with all key stakeholders, so that they're just a phone call away. These are people you can reach, these are people you understand, and therefore you are the touch point, critical touch point for everyone in the organization when it comes to resolving issues, preventing issues, or getting effective advice. So I want to conclude at that point, and I'll be available for Q&A. I hope I have given you some insights that you may find useful in what it is you do, and I wish all of you very successful deliberations. Thank you very much for giving me this opportunity.
Thank you very much, Dr. Moria, for this amazing, I feel like there's so much to take on. I don't even know where to start, but I feel the big takeaway from what you just said is we need to figure out how to be integral in the whole process, and then that will change how we view ourselves as in-house counsel. Thank you so much for this message. So as Dr. Moria has said, he will be leaving the webinar a bit earlier, but just after the next speaker. So we'll have a little bit of time to ask him questions. So if you have any questions, please direct them to the chat line. I now invite Hope to introduce our next speaker. And our next speaker will be taking on from where Dr. James left. And he's basically telling us, look at the challenges. This is how I'm challenging you. These are the opportunities you have. Embrace them. Hope, please introduce the next speaker.
Thank you, Gloria. It's my pleasure again to introduce our next speaker, and that is Honorable Justice Geoffrey Chiriawire, Justice of the Court of Appeal and Constitutional Court in Uganda. He's also the chair of the ICT and Law Reporting Committee of the Uganda Judiciary. He's a judge of the Arbitration Tribunal of East African Development Bank, a panel member of the INSOL International College of Mediators, London, and an associate of the Uganda Insurance Institute. He was appointed as Judge of Appeal on the East African Court of Justice Appellate Division in August 2015. Previously, he served as head of the Commercial Court Division of the High Court of Uganda, the chairman of the UNESCO Appeals Tribunal in Paris, France, CEO of Pan World Insurance Company Limited, and now Lion Assurance Company in Uganda, and chairman of the Uganda Insurers Association, among others. He has also done consultancy work for the World Bank and IMF and written a number of papers in the area of alternative dispute resolution, and is a contributor to 3 published books. Justice Chiriawire has also done adjunct teaching at law at Makerere University, Ndeje University, and Uganda Matters University, all in Uganda. He holds a Bachelor of Laws degree from Makerere University, a Master of Laws degree in International Law with a bias in International Economic Law from the University of London, UK. Justice Chiriawire, you're welcome to speak to us this afternoon. Karibuni sana.
Asante Hope, thank you for your kind introduction. I hope people do not take everything you say to be gospel truth, but quite a bit is okay. It's a pleasure to be part of this webinar. This is the second that I have had an opportunity to address as part of the East African Law Society. I think I addressed one about 3 weeks ago. So it's a pleasure to be here. I have been asked to talk about just 5 things that would challenge an in-house lawyer. And looking at the first slide and listening to Dr. Moira, for whom I thank him for his presentation, there's a lot that we have in common to say. I feel a little bit like a dinosaur in this presentation. Personally, I was called to the bar in 1988, so that's a long time before Dr. Moira was called. But just talking a little bit about my story, I was appointed company secretary of an insurance company, Pan World Insurance, which has now been bought and become Sanlam, in 1994. So I was an in-house lawyer. Previously, I'd worked for the Office of the Attorney General. And in 1994, I became a company secretary. By 1999, I had become the CEO of that company. And by 2001, I had become the chair of the Uganda Insurers Association, the first lawyer to become chair of that trade association. And also in 2001, I was appointed by the Minister of Finance to the regulatory body of the Uganda Insurers Association. Of the Uganda Insurers Authority. So you can see my progression through the years. And indeed, by the time I was appointed a judge of the High Court in 2003, I can assure you very many people had forgotten that I had studied law. They actually thought that I was a businessman. So if you can show the first slide, the issues of in-house lawyers are very, very important. And I'm glad that an overview has been made. But let me start with certain perceptions that are out there, that in-house lawyers are expensive and therefore they are better outsourced. And therefore you have a lot of organizations which really do not have in-house lawyers because of that perception. They outsource their services. They also have this perception that in-house lawyers are argumentative theorists and do not understand the business, and therefore really they should not be part of the team. There is also this perception out there that, in-house lawyers do not generate income for the business, and therefore they should not be part of it. Now, these are some of the things that need to be dealt with if you want to acquire visibility as an in-house lawyer, and also to chart a career at the same time. So moving on to the next slide, I found this definition very instructive, and I hope it will be useful to you, that an in-house lawyer is a commercially driven, highly trained legal advisor who works within an organization. I think that's a very good definition. But allow me to bust one myth straight away, and that is that an in-house lawyer is not a back office person. He's not a back office executive. He is really part of the team of the company. He is an essential player for corporate success. There is this feeling sometimes that when you become a corporate lawyer, it is because you do not want to become a litigator. It is because you do not want to become a judicial officer. It's because you wanted a quiet career. But this is all not true. If you are going to be a successful in-house lawyer, then I want to put it to you that you need to become a go-getter. You are not a paper pusher. You are not a paper pusher. You are the voice. You are the eyes. You are the feet of the company. Remember the case of Solomon and Solomon. The company is an legal entity different from the board, from the management, and from the shareholders. But it needs eyes, it needs a brain to think, it needs feet to walk. Now, if you become that, then you become the essential in-house lawyer that you are hoping to become. So my first challenge is this, and that goes to the next slide. You need to know the law. You need to know the law. You cannot advise what you do not know. As we say in Uganda, if you know, you know. Now, if you are not schooled in the area of commercial or corporate law, or any other area for which you are an in-house lawyer, you will find yourself being marginalized. Now, the largest number of in-house lawyers that we know of are really absorbed in the commercial and corporate law area. And this is the widest span of law, right from land law, right through banking, import and export. The scope is intellectual property. It is very wide. And you have to be knowledgeable in all of these areas in order to provide the necessary advice that the organization you're working for requires. And this is also the case if you're an in-house lawyer for other specialized fields. For example, if you're in telecom, you must be familiar with telecom law. If you're in aviation, you must be conversant with that, or even if you're in environment, whatever field that you are called to be employed in. Now, the worst thing that can possibly happen, in my view, is that there is failure on your watch. For example, there is a regulatory sanction, there is receivership, or there is, as we have seen, bank failure. This is really the watch of the in-house lawyer. You are the person who should be able to analyze the risk, as Dr. Moira was talking about. So really my first challenge to you is you must know the law, because that is what you're being hired for. That's why you are in-house lawyer. The second challenge and I'll try and move on quite quickly, and you can move to the next slide, is you need to know the trade and business in which you have been hired. It is therefore, having said that you must know the law, it is not just enough to know the law, you must also master the trade and business in which you're hired for. And I'd like to suggest to you the 3 R's in this respect, and that is retool, retool, retool. What do I mean by this? Is that even if you know the law, you need to retool yourself to be able to fit within the kind of trade or business that you have been hired in. So if you are hired as a company secretary for Kenya Airways or Uganda Airlines, you must retool yourself to understand what is the aviation business all about. So you really need to retool yourself. And part of that process includes what I would like to refer to you as the 3 C's, and that is consult, consult, and consult. If you do not know, consult. Do not pretend to know what you do not know. Whatever advice you give, make sure it is on sound footing. You must remember that the law does not operate in a vacuum. The law must operate in the context of your employment. If this is not the case, you will lose visibility. You need to use the law to lift the business that you are part of to a higher level. The higher the level of attainment for the business you work for, then the higher your own visibility will be. So what I'm trying to say is that the more you know about your hired job, the more influence you can have in its direction. Of course, this may mean that you have to do a lot more hours in your job than just do the regular 9 to 5 in order to achieve this goal. I remember when I was in the insurance field, I became an expert on bonds. I was not an insurer, but I became an expert on bonds. And I was constantly consulted, not just as a company secretary, but as a legal expert on bond issues. I remember that I had acquired that proficiency whereby I would be called to appear on the 9 o'clock news to give an opinion on market trends. This is the sort of thing that will give you visibility. My third challenge is, of course, what is part of what we're doing right now is to have continuous legal and professional development. You really need to know what is happening and keep pace with it. I mean, right now, the biggest question is, what is business like during and after COVID-19? It is important, therefore, that you tool yourself where you are not able to be tooled, whether at law school or at the bar, wherever it might be. I remember very early on my becoming a company secretary, I went for courses on how to become a company secretary, how to get involved in development planning, how to determine a vision, mission, a SWOT of a company. All of these things were very important. It is therefore important that you don't only continue studying or attending workshops for the legal profession, but you should also attend workshops, seminars, and conferences in the area in which you are an in-house lawyer. Also purpose to make contributions and even contribute papers. I remember 2 instances that gave me visibility. One was a discussion in Uganda at a conference of the case of Uganda Motors and Waba Holdings, in which I argued that the Supreme Court of Uganda, by that decision, had removed away the substantive law of insurance with regard to fire insurance in Uganda. And that created a big buzz all over the place, both in the industry in the legal profession, and even within the judiciary. And it actually caused an amendment to the law. I recall that I was once called, I believe in 1997, to be a keynote speaker at the annual conference of the Uganda Insurance Institute. And all of this is the sort of visibility that I would like to encourage you to get involved in. If you can go for professional courses, whether you want to do a master's in business association, an ICSA, an ACCA, CIMA, or CIGIMA, I think these are all useful. And I think some of these qualifications you already had, Dr. Moira has gone through. The fourth challenge is to know the numbers. You know, the challenge I have with lawyers, and probably myself as a young lawyer, is we do not like numbers. We sometimes became lawyers because we didn't want to do the sciences. We didn't want to be involved in the numbers. But let me tell you this, business is all about numbers. Whether you're making a profit or whether you're making a loss, it is all about numbers. When I was appointed CEO of my insurance company, my board chairman made one startling remark to me. He told me that nobody is going to present the financial reporting of the company on my behalf to the board or whether to the shareholders, that had to be done by myself. In other words, that I had to show and demonstrate that I understood the numbers that were running in the company and could justify whether we were doing well or whether we were not doing well. This was a big challenge, but I had prepared myself for it because I had attended a course on accounts for non-accounting executives. And this really helped me to understand how to present documents like balance sheets, profit and loss account, and also whatever strategic plan that the company needed to put out there. So you need to be able not only to know the law, not only to know the business, but you also need to know the numbers. This is a very important area. These are very important areas if you want to achieve the visibility of the in-house lawyer that you seek to get. And even for your department, it is important to show that you're managing your in-house lawyers department within the overall objectives and strategy of the company. One of the things that really cause in-house lawyers to suffer is that they become a big loss center for the company. It is where the large bills for external lawyers go out. And this normally surpasses the projected budgets. But one of the things I became really good at was to keep my department within the budget of the company for that particular year. And how did I achieve this? One is that I ensured that my company was licensed as a law firm. So actually, my company, Panworld Insurance Company at the time, became the first private company in Uganda to be licensed as a law firm. And this meant that even though I did have external counsel, a lot of the work which I thought were routine, I would do myself. And even where I gave external instructions to counsel, there are times when it was necessary for me to appear in court and argue a case side by side with the external counsel, and this helped to reduce on costs. And actually, I became quite notorious for this because I do recall the times I would appear. I remember one time, one judge said, if Mr. Kiriabwire is here, this is a very serious case, because they always knew when I showed up that there were very deep issues to be dealt with. And the other area which I really tried to work on very much was using alternative dispute resolution to manage the kind of disputes that came our way. I'm not really going to talk much about the company secretarial things. Mr. Moira has spoken to them. I want to talk about these broader issues. So my theory was very simple, that I either win the case or I mitigate the loss. So that way we managed to do well in terms of the numbers for my department. The fifth challenge is to build your own personal, or should I say, to build your personality. This is an individual trait. My chairman once told me that your personality is your purchasing power. Or if you want, you can put that as the triple P. That if you have the right personality on top of all those other things that I have spoken about, you will be sought after. You need that kind of personality in order to influence, in order to be accepted as a team player. One of the challenges that we have as lawyers is we always want to brag that we are lawyers. We are learned friends and the other people are not learned. That kind of discussion never took place when I was in my corporate days. I downplayed the fact that even to become a lawyer required a lot of reading, required a lot of excellence. I worked with my workmates at the level at which they were. I moved away from the use of the word I think, or for us in the legal department, we say. No, we always used to talk about we the company. And that allowed us to be part of the company. I would like to say that even though you are part of the in-house legal team, if you want to acquire visibility, then you need to even volunteer where there is work, where you can help, which does not involve giving legal advice. This is a very important aspect of making sure that you're part of the team and that people can see you as a reliable team player. This is something I used to do quite happily, even as a company secretary. Very often, if there was need to go out with a marketing team, I would go out. If I knew somebody where the marketing team would want to go, I would go with them. And that would make them very happy. And if we were involved in shows, for example, exhibitions, I'd be very happy to be part of the team which was exhibiting. And it didn't take long for the CEO of the company to always then appoint me as in the position of acting CEO when he was not at station. So I also ask of you to build your own personality. Let me make a few recommendations because our time is short. I think the first one you have dealt with. I think in order to gain the visibility that you want as in-house lawyers, you can create a subgroup within the East African Law Society, which I believe you already have. You can start an online magazine. You may be aware that there is one already online called In-House Lawyer. It started in 1992. I used to refer to it quite often. And I want you also to purpose to see that if you want to be an in-house lawyer, that you actually do this as a career. You know, you want to grow through the ranks and not believe that because you're an in-house lawyer, you cannot achieve, for example, a position of CEO, a position of board member, and also to see that you are portable. It doesn't matter whether today you're an in-house lawyer for an aviation outfit, but tomorrow you can be an in-house lawyer for a banking outfit. This is what I think would help you gain the visibility that you seek to get. In conclusion, I came across this statement, which I thought is instructive, that as a modern in-house lawyer, you need first-class legal skills and knowledge of legal issues, risks, and changes in your organization and industry. Business knowledge and skills, including service delivery, project and performance management, financial acumen, and innovations. I think that nails it for me. So I thank you for listening to me, and again, wish you the very best of this webinar. Thank you very much.
Thank you so much, Justice, for your insightful discussion. I kind of feel like you have really schooled us on the opportunities that have always been right there in front of us and we just didn't take up. So thank you for highlighting this for us. And I can see from the chat group that a lot of people they have pointed out key takeaways for them. So to move on to our next item, I would like to invite Hope to handle the Q&A session, because Dr. Moria will be leaving the session, the webinar shortly, and would not want for him to leave without answering some of the questions that the participants might have. Hope, kindly please take us through this.
Thank you, Gloria. Thank you, Justice Chirawire, for your presentation. Very insightful, very challenging. We have two questions for Dr. Moria. The first question, and I'll read both of them so he can answer them one after the other. The first is from Elizabeth, who says, from a lawyer to a chartered financial analyst, what drove you to not just have a fair understanding of finance, but to become a CFA? The second question is from Brenda, and Brenda says, what simple steps can one take to start thinking like a leader? Those are the two questions we have for you, Dr. Moria, if you could answer them. Thank you.
Thank you very much for those questions. But first, let me congratulate Honorable Justice Chiawire for a wonderful presentation. I have really enjoyed it. And I've also learned a lot, and I'll actually hope maybe you'll send it to me, because I'd like to share it with my entire team, not just the in-house counsel. It has a lot of insights. Thank you very much. It's a pleasure for me to share a platform with you, Justice Chiawire. For me, what drove me to be a CFA, because my undergraduate degree was in law, is what Justice Geoffrey Chiawire was talking about, is that desire to be a subject matter expert in the environment I found myself. I found myself working for an investment company, and investment in the world of finance. And you see, it is my belief that there's no limitation. You know, as a human being, you can master any subject. And there was a need for me to acquire mastery of the subject in the industry I found myself in. And at that time, until now, actually, the leading qualification is a CFA qualification. And that's why I enrolled for it. And I engaged in self-study and passed all the papers in the first attempt, and then started teaching introduced it at the Strathmore College, now Strathmore University. So very much to what the Honorable Justice was speaking about, that it's important for us to learn, it's important for us to teach, so that you can raise your influence, because again, as was said, law does not exist in a vacuum. I believe if I'd found myself in a different industry, I may have taken a similar interest and sort of wanted to build my knowledge in that industry. You know, I think the simple steps is you know, always put yourself in the shoes of the recipient of your services and try to add value and think critically, what is it that I need to do to add value to those I engage with, and how am I going to be the best possible purveyor of that service now that you have had that blessing or opportunity to be of service? Because there are many people who have gone through the same experience but have not had the same opportunity. So I think for me, it's to have a deep respect and appreciation for the opportunities that you have, and say, look, what can I do within the restraints of the opportunities and the skills I have to really offer the best possible value and to play a role in steering whichever organization I am in, to play my role in the position that I serve, because it's in doing so that people identify you and give you greater responsibility, and you continue to serve in that. So don't constrain yourself and put a label that I'm in tax, I'm in company secretarial. The whole organization really is your oyster, and you want to continue to add value and to have that brand positioning as that person who is constantly adding value and who really understands what it is that they're talking about, and they put their best foot forward. So working on your attitude as well as your aptitude is critical. So a lot has been said about aptitude, but also the justice spoke about attitude in terms of personality. I think those two things are very important. Thank you very much. I hope I've addressed the two questions.
Thank you very much, Dr. Moria. Thank you for your time. We know you have to leave the call, but we recognize your departure and the time that you spent with us. Thank you so much, Dr. Moria.
Very much. Thank you very much, ladies and gentlemen. It's been a real pleasure. Thank you very much.
Thank you. So we move on to the next part of the panelists. We'll be starting with Dr. Siobhan shortly. Siobhan was a former company secretary who also turned CEO, and she'll be talking about the top 5 things that keep the CEO awake and how the in-house lawyer can pitch in. I invite Hope to introduce her. Thank you.
Thanks, Dr. Siobhan, whom I am meeting again after more than 20 years here. Managing Director of Babil Rwanda. Babil is a subsidiary of Babil Digital Health Care Provider whose millions of everyone on earth. Prior to that, she was the company secretary and head of corporate affairs at Bank of Kigali, in charge of the bank's legal affairs, investor relations, public social responsibility. Prior to joining Bank of Kigali, she was the company secretary and chief legal officer for Rwanda. That's Rwanda's national carrier. She serves on several boards and has a PhD from Glasgow Caledonian University in Glasgow and a Bachelor of Laws degree from Makerere University, Uganda. Dr. Siobhan, you're welcome to make your.
Thank you so much, Atuhere, for that introduction. And thank you also for inviting me to this panel discussion. I don't feel like I'm very new because I'm familiar with some faces, Gloria, Sharon, and some of the other panelists as well. So thank you so much. When I was told to talk about this topic, it kind of gave me time to sort of reflect on my career and sort of like self-assess, you know, what kind of company secretary was I? And now being a CEO, how relevant, useful was I to my CEO? And was I effective in that sense? And so what they've asked me to talk about is 5 things that a CEO, you know, what keeps them awake at night. And I think I'll just quickly go through them and maybe tackle a couple of things that will allow us to, you know, to be more useful to sort of to the CEO. So the first thing I did write down was a CEO is interested, obviously, in the success of a company, the success of the strategy, whatever that strategy is. Brand. So I run a digital health company in Rwanda. It's new, and one of the focal areas is therefore to, you know, how do I create brand awareness? How do I create a mark? When I used to be in Bank of Kigali, we used to talk about, when you talk banking, just like how you accidentally, you want to say Bank of Kigali. sometimes you don't say toothpaste, you say Colgate, because one is synonymous with the other. And CEOs get obsessed with, how do I create that brand that would be, that would be recognized. And brand creation is not just, and is definitely about the strategy, success of the strategy of the company. And it's not external brand as well only, it's also internal brand. How do I make my employees enjoy working in the company that I work on? What do we stand for? What are our values? Do we keep to those values? And especially if a company is young, you sort of have the pressure to, or because you're really creating the vibe, or this is what it's like working at Bubble. This is, it's a lot harder to change a big brand to kind of come and put your footprint there and so on. But anyway, that's one thing. The other thing as a CEO is definitely around looking at the bottom line. What is the P&L? Who gets me to the bottom, to the end of whatever of the line? I remember a personal story when I was as a company secretary in one of the places that I have worked, getting into it with one of my colleagues. As company secretary, they were head of, they were more on the business side of things. And in this particular situation or argument, I was right. The CEO knew I was right. And I remember just putting my position forward and just insisting that this is the right position. And I was very disturbed, and I spoke to one of my mentors, and highly recommend that all of you have mentors, to basically just, this thing was really disturbing me because it was also speaking to what my values were. And I'll never forget what he told me. So if you can't work with this person and you have to part ways, yeah, who do you think the CEO needs more? Like, sit back and think about it. Who do you think the CEO needs more? I didn't even spend a lot of time thinking about it because it was the other person. The other person, because I could see even the way we work, it was like the backbone of the CEO. He understood the business, he did this and this. He was basically the de facto number two, but almost self-created number two. And I just kept feeling like, yeah, I need to get to a place where I am so integral to the business. And I think it's the point, and it's the point of this conversation, right? So I just wanted to first of all line the couple of things they've told me to talk about, and then go in detail in them. The other thing is around people, problem solving. We are dealing with human beings, and so we need to realize that we need to problem solve and so on. The other thing, obviously, is having the right people on the bus, hiring, letting go of people. How do you do that, and so on. And obviously, part of making your strategy work is the relevance of networking. So let me go to maybe speak to, those are like maybe the 5 things that I think that make a CEO, that are very critical for a CEO. But the other part of the question is that how relevant, or how can the in-house counsel chip in to make sure that they are relevant to this. So one of the things I want to talk about is understanding the business. In any business that you work in, really invest the time and energy to understand the business, because you then remove yourself from a technical legal person, and then it's just a legal matter where you see things in black and white, when in reality, there's a lot of color in business, and it's not just gray, but there's just a lot of color. So there's a lot of context you need to really understand and chip in. So invest the time and energy to understand the business, to understand the priority of this particular issue. And also, you don't end up in this place where, I don't know whether, I mean, from my experience, you have a lot of lawyers, it's almost like they have been told to say, this is impossible, this is not in line with the law, you know, this can't be done. And yet you really need to understand, because it's really about perspective, you know, how do I become positively useful in this particular scenario, beyond just saying this can't be done and so on. So one of the things I suppose that you need to do beyond understanding, you need to understand the business, number one, and also just be creative and positive. So one of the things that happens in a workplace is people basically saying this can't be done. And especially the lawyer who will then come and say, oh, according to Article 25 and of this and this, clearly this can't be done, or this is illegal. And sometimes you like, which article are you referring to? Bring the law, let us, I mean, I'm a lawyer too, let's look at this and interpret the fact. And sometimes it's really perspective. It's I don't want to call it lazy, but it's just basically just giving your opinion on how impossible things are, yet something really has to be done. So I think that as a lawyer, if you if there's a position on something and something that you want to do as a business, whichever field it is, and what is the, how can you be supportive? How can you be positive in a way that gets the thing done, whatever it is, you know? And I'm not, of course, I'm not advocating to go the illegal route or you know, when something is whatever, but the important thing is understand the business, what needs to be done in this particular scenario. And you'll find that when you understand the business, you bring a bit of color because you have the legal background and you bring the color to sort of the conversation. So that is one. The second thing is, and I think I talked about, was people, right? There's nothing more critical in an organization like having the right people with the right attitude, with the right expertise on board. A legal person might not be involved in the everyday hiring of a member of staff, but when the member of staff comes in, how do you support in terms of orienting and stuff like that? But the more critical elements of a legal counsel, which is a very big problem for a CEO, is when you need to let people go. The law is very clear on this, but I have not seen so many companies that have looked at, if somebody, we want to terminate this person for poor performance, what are the internal steps that I need to do? What does the hiring manager, what does the relevant manager need to know to get there? So we're part of a global company, Babylon, and we have offices in the US, in the UK, in different countries, and we're a huge group of people, about 2,000 employees. And there's certain things that are systems and processes. So I was asked, to have a look at, what happens if you want to let somebody go for poor performance. It is so elaborate, place by place. Who is the supervisor? What is the conversation that needs to happen? What is the conversation needs to happen at the level of a review? What is the sort of documentation that you keep? What is the sort of systems and processes that you need to keep in place? I think that the legal counsel can play a central role without even being asked, like this is something that is very critical in very many organizations. And I don't know in other geographies, but in Rwanda, definitely it is an issue where it's a very litigious place and so on. So just making sure that there's a clear systems and processes in place to make sure that it's a very smooth hiring, letting go of somebody, right? And the legal person has to play a central role. The other thing is, it's very important to make yourself useful. And sometimes it's not, I'm a lawyer and this is the legal position on things. And I was reminded, I'll tell you a story very recently. I was going through a negotiation of contract with the government. And in many of these meetings, you go with a number of your staff, 3, 4 people. And having coffee with one of my friends, you know, they kind of say, oh, I think CEO, you have preferential treatment over this, towards this person, towards this lady more than anybody else. And I took a bit of time to reflect on it, because that was feedback to me. And I was thinking, what draws me to this specific group of people or person? And I realized one thing. Every time we came from a meeting, it was always not CEO, quick email, CEO, these are the things that we said we're going to follow up on. How can I help? A text message a couple of days down the road to just say, there was this problem. How do I was thinking about this particular situation. I think we should do this and this. You kind of look at this person and you're gravitated towards them because they're thinking about the problem. They're not leaving it to the CEO. And they're basically chipping in and giving advice and where need be, and kind of saying, how can I support here and here? Or what if we did this? So I was thinking about this problem that we had in this meeting. How about we solve it like this? Someone being a thought partner. And I think that when you become a thought partner of your, of your CEO, I think that then you can sort of, be very influential. So influence is not really just, I'm a company secretary or I'm head of legal and therefore I'm influential. It's like everyday influence in a place of work. You speak to understand the need and speak to that need. And I think that that's how you amass influence. The other thing is we take it for granted that networking is probably something that you'd leave to the CEOs, or if you are the partner in a law firm and that's how you get business and stuff like that. But it's very important to, if you do have networks, to bring in networks at a place of work. If you're dealing with this particular situation and you're like, oh, by the way, I know so and so, I think that because a lot of these problems are solved through networking or through connections that somebody might have. So don't take it for granted that you don't need to have these networks at a place of work as an in-house counsel. As they say, network is net worth, right? And I think it really helps if you bring your whole being, including your networks and stuff, to problem solving, to a place of work, to that, right? Then the other thing is the importance of following through. There is nothing as bad in my books as somebody's supposed to get something done, and 1 week down the road you're asking them and you're like, yeah, I sent it to the legal team, or the fact that you didn't follow, you've sent it to the legal team, so was the work done? Was this particular thing completed? So it's that responsibility to just look at the whole loop. We needed to do X. X needs the following dependencies. I have worked with these dependencies and I have gotten the work done. Bring the cup home, if it's like bring the trophy home, and maybe what I was thinking about is maybe in terms of a relay. There's so many times when you're starting the race, you have to give the stick or the relay to the next person, and you don't care whether the person is walking or they have fallen or they have whatever. And then your CEO asks you and you're like, yeah, I sent it to legal. So you haven't come to legal to say how far with this thing. The legal team probably has, or I have sent it to this other person, or the legal, in this case, we're talking about the legal team. Yeah, I sent it to the department, You're not bringing this, you're not winning the race, and either you don't realize that this is something that you're responsible for, and therefore you just feel like you're part of the process. But I think any CEO would appreciate the kind of person who follows through something to the end, and then reports back on it and say, I have liaised with so and so, this was my dependency, but then it's been full circle and I have brought it home. So I think that that's very critical in any place of work. And I think when you understand the business, you have 20 different things that are on your plate. because you understand the business, you're able to prioritize, you know? You don't do things because as a legal counsel, this one came first, you know? Because this came 6 days ago, I'm going to deal with this according to how they came. If you do understand the business, you also understand what the business priorities are, and therefore you're dealing with things based on what the priority is and how relevant something is for the business. I think those were 5 things that I wanted to share. I don't think yeah, that's it from me. Thank you so much for inviting me again.
Thank you, Dr. Byamukama. Siobhan, as I usually like to call you. I think for me, the key takeaways basically from what you just said is one, apart from the general conversation about understanding the business, you're basically asking us to contribute to creating clear systems and processes and to be useful. And once we have that in mind, be useful, then we're able to ask ourselves better questions about how we can contribute better as in-house legal counsel. Thank you so much, Siobhan, for your insight. So as time is not on our side, but we'll quickly move to the next set of speakers. The next set of speakers are in-house lawyers. Sorry, one is an in-house lawyer, the other was a former in-house lawyer who is now an external practitioner. And they'll be talking about the power of versatility as an in-house lawyer. I now invite Hope to introduce the 2 speakers so that they can proceed. Thank you.
Thank you once again. The next speakers are Ms. Emily Gakisa, a partner with Otis Advocates here in Uganda. Emily is a risk management and governance professional with wide-ranging experience in the financial services sector, but currently in private legal practice. Emily previously worked in the legal and company secretary, regulatory compliance, and credit departments in the financial services sector and has expertise in capital markets. Emily is passionate about business growth, leadership, good governance, and is also grounded with excellent strategic thinking capabilities. Emily has an MBA from the University of Leicester and an LLB from the University of Dar es Salaam. The other panelist that I would like to introduce is Ms. Sharon Mazimaka, the General Manager, Corporate Services and Company Secretary of MTN Rwanda Sale. Sorry, Sarah is not coming on for this particular panel, but apologies for that. Yeah, the other person I'd like to introduce is Mr. Ibrahim Kito, the Chief Legal Officer, Projects and Dispute Resolution, Kenya Electricity Generating Company. Ibrahim is an advocate of the High Court of Kenya with more than 10 years hands-on legal, corporate, and public sector experience. He holds a master's degree in law specializing in public finance and financial services law and a bachelor's degree in law from the University of Nairobi. He is also a graduate of the Kenya School of Government Strategic Leadership Development Program and an alumni of the Oxford Leading Strategic Projects Program at the Said Business School, University of Oxford. Those are our 2 main speakers for the next session.
Ibrahim, you can proceed.
Yeah, okay, Gloria. Let me start off by just introducing the context of my presentation. And just to start off is that my presentation is on the specific aspect of versatility. which is the expectations of colleagues who require numerous views on matters from the legal department, and how can the in-house lawyer prepare himself better to meet the said expectations. So yes, that is the particular segment I'm dealing with in my presentation. So to start off, I'll just want to give some clarification in terms of the meaning of the word versatility. And of course, borrowing from Oxford, versatility basically means the ability to do many different things, maybe at a go. And in other words, it's the ability to adapt or be adapted to many different functions or activities. It's the same definition, or closely related to that definition is the one given by the Cambridge Dictionary, which is the quality of being versatile or being able to change easily or to be used for different purposes. By introduction, I'll say that in the past 15 years, there has been a revolution in the legal profession. And this revolution has been that the general counsel and other inside lawyers have risen in quality, responsibility, power, and status. And once second-class citizens in corporations and the legal professions, they have become co-members of the top corporate management, equaling or even surpassing the chief financial officer and the finance function. Typically, I think, and I will not dwell so much, we all know that the key functions of a legal function is basically litigation or dispute management, contracts management, legal audit, and compliance. Then, of course, closely related to that is the role of the corporate governance and secretarial support, and of course, the general legal support. But then recently, we've seen the role of corporate planning and strategy come in handy. There is typically what we call the dual role of a legal counsel for playing the role of a partner or creating alliance with the other departments. And of course, the other role is the role of a guardian role. So typically, in most cases, these two roles usually overlap, or rather they have competing interest, in that people can usually say that you cannot effectively play the role of a partner or being so deep into transactions or operational issues, but then you also play the role of a guardian role. And my presentation speaks to the fact that all these functions are very important and critical for an effective in-house counsel. And to that extent, then you need to have a way in which both the role of a partner and that one of a guardian needs to be balanced. And of course, being a guardian means that you are the conscience of a corporation, and the effect is to ensure that then the best interests of the corporation prevail as opposed to private interests. And of course, the partnership role means that you cannot really shrug the need to actively participate in operational and even management issues in the name that you want to remain to deal with checks and balances. But rather, the ideal situation is that you need to ensure that you are actively participating in operational and even management issues, if at all you are going to be an effective counsel. And I think the case of Enron speaks to that. It was a case whereby the in-house counsels were seen to have failed and abdicated their role in that they were not effectively being seen in dealing with the risk, which essentially saw the fall of Enron alongside the other issues. What is the greatest challenge of a general counsel? This is one of the questions you need to answer. And the question is that the greatest challenge of a general counsel is to reconcile the dual role, which we've actually spoken about, the guardian, and of course, the role of a partner. I will take you through the journey of an in-house counsel role, maybe from the old days up to this particular time, whereby there's an indication that there's need for a shift. And this is a shift from in-house counsels or general counsel seen from naysayers and operations, and then or even stoppers to critical advisors necessary to move the business forward. From mere internal compliance officers to strategic corporate counselors and managers of external legal services, from papers all over to tech-savvy professionals, from impenetrable black box to sharer of knowledge to all company employees. And this speaks to the need to disseminate information on legal issues or sensitization to all members of staff. This is the quintessence of the in-house legal department's recent evolution. The ideal in-house legal department is no longer focused on the general duties related to offering legal advice, ensuring legal compliance, contracting, and offering company secretarial support. While the above roles cannot go away or be diminished in importance, they certainly have been expanded as demands and the rules of the game in the legal industry and business in general have changed. Of course, in big companies, the responsibilities that fall into gray area between business management and practicing law are being pushed into legal operations. And this is only the beginning in an ever-changing business environment that constantly challenges the traditional legal department and classic professionals. We also face a shift in the role of the in-house legal department from the consultants of old to entrepreneurs. What are the expectations of colleagues who require numerous views on matters from the legal department, and how can the in-house lawyer prepare themselves better to meet the said expectations? This is actually the singular largest important question I'm supposed to address. And I'll just pick out a number of traits, values, or expectations expected of an external legal counsel to deliver on the said expectations. One of them is actually the culture of high performance and excellence. We also have the need to install full documented brief or background information informing any requests from the departments. There's also need to create accountability on the user through approvals, execution forms filling and execution, and ownership of technical terms, especially for contracts. I'll seek to explain this particular point from a practical perspective. A typical person working in a company like an engineering company will expect that most of the contracts you are dealing with are actually engineering and technical contracts. So what is expected is that because a lawyer cannot speak to the technical details of the contract, then you need to ensure that the technical terms of that particular contract are owned by the user. May it be the engineers on the ground, or maybe people actually on the field, and people against which the contract is being sought to be done. So there's need to ensure that ownership is created. Then another critical thing, which I think has already been mentioned by Dr. Mori and a number of panelists, is that you need to be a master of your own field and jealously guard or brick-wall it from being undermined by other professionals. I usually say that it's always very important to avoid pseudo or quack lawyers' opinions. And typically this happens whereby you find that as a lawyer, internal counsel, you are not so exposed or you've not mastered your field. And when you are perhaps in a meeting or you are trying to work on a solution, you find people who are essentially not lawyers who want to creep in and offer legal solutions to issues. And the issue I'm trying to raise is that you need to ensure that you give credence to yourself by mastering that particular area, so that anything relating with law, you are the one to give the final opinion, but not anybody who is not a lawyer. The other thing is, of course, to embrace a culture of constant learning in relevant and emerging practice areas, because we all understand that the law, as you learn it when you're in campus and even law school, and even in your preliminary years of practice, keeps on changing. Law is never static, it keeps on developing. Statutes are being churned every day. And of course, practices are also changing. So it's important to always keep on with a constant learning. The other thing which has just been mentioned by Dr. is that you need to build a network of trusted and readily available free consultants and colleagues or counterparts in your area of needs. This includes having networks in strategic institutions like regulators. And of course, if you're working for the public sector, you need networks with the Office of the Attorney General, of course, alongside other networks. When we speak about free consultants, these are actually your peers in the industry and people who perhaps have been able to deal with issues which you need to address before, so that then you don't need to reinvent the wheel. And they can easily give you an answer, you consult, and then you can be able to move on. And of course, that kind of approach speaks to efficiency, in that you're able to get a solution within the shortest time possible, so that then you keep business going and you're able to offer a solution to the business. The other thing is that you need an in-house counsel. As an in-house counsel, you should not need you should not in any way be a rubber stamp. You should insist on being involved and call for full disclosures and documentation by asking the hardest of questions if need be. Quoting one Ben W. Heinemann, the former top lawyer for General Electric for nearly 20 years, and a distinguished senior fellow of Harvard Law School's program on the legal profession and corporate governance, also doubling as a lecturer at law school for Yale. He said that, I do not think that the choice for general counsel and inside lawyers is to go naive, as I had said, for the business side and be legally or ethically compromised, or to be an inveterate naysayer excluded from the key discussions and decisions and from other core corporate activity. I think Dr. spoke to this, that as an in-house counsel, you really need to understand your role in being involved in key critical decision-making, and especially where your name is going to appear and your signature as well, for reasons that you are going to be held accountable to that. And for that reason, then you also need to ensure that for everything you are called upon to support, you do not only approve, but then you ensure that you are involved in critical decision-making, maybe from the start point. And if you are not involved, then you need to ask for the background information to offer you support and the confidence that whatever you are going to approve is actually aligned with what is expected and there's nothing illegal or unethical to deal with. A critical thing is, of course, to have in place service level agreements with other departments. And this is also to ensure that then whenever somebody has a complaint or has already given work for you to deliver, then you're able to work within the service level agreement, which is a document against which they can hold you to account, and a document against which, if they push you so much, then you can tell them, you know, I'm still working within the service level agreement I have with you. So it's a document of accountability. The other thing is, of course, I haven't spoken about is that never overcommit to your client. And of course, our client in this particular case are the other departments. You need to remain modest in your commitments and importantly, ensure to fulfill them by delivering earlier than expected. The key word is you need to learn to surprise your client by delivering within the timelines earlier than they expected or earlier than you had committed. Critically, and something which has been emerging, especially amidst a different working environment, which may never always be good, is the need to develop what we call emotional and adversary quotient. And when you talk about adversary quotient, it's just the ability to be able to survive or remain, you know, agile within, for lack of a better word, toxic or not so favorable working environment. Just the ability to adapt and the ability to be able to still deliver despite the hard or difficult work environment you are working with. If anything, there's an argument that growth is not where there's comfort. There's bigger growth whereby you are pushed to the wall, and of course, where there are challenges. Another thing to look at is, of course, the need to develop a culture of seeking clarifications and written communication from your clients, and these are the departments. Very important, the culture of seek clarification where things are not clear, and also insist on having written communications. I usually say that it's good to avoid corridor communications, and the approach should be that which was said in the corridor, let it be implemented in the corridor. So it's very important for lawyers, because people are usually looked at as people of documentation. It's very important to insist on written communication, especially on controversial or far-reaching issues. It's also the culture of punctuality and the respect for time and working within schedules. Of course, this speaks to prioritization of assignments, and of course, the need to diarize, and of course, having tools within which to work with as a reason to allow you to remember and also ensure that then assignments don't fall by the wayside, only to realize when they have already reached the deadline. A very critical thing for people who are majorly involved with complex transactions or even projects is that there is need to embrace what we call work breakdown structure and agile approach to delivery of assignments. And this should be based on skill sets and staff available. talk about the work breakdown structure, I'm looking at a typical thing like a complex project. Perhaps you are delivering a power plant or a road project, which calls for several specialties to deliver. Then, of course, what you need to do is to identify the various parts of the work and then break them down and ensure then that different people based on their specialties are also allocated the assignments. And then what remains for you as a lawyer is to actually to be able to come and assemble the various segments together based on the input given by the various teams. And of course, closely related to that is also the need to schedule the particular assignment so that then you don't find a case whereby you continue with milestone 2 when you are supposed to have started with milestone 1. A typical case is whereby you are dealing with a transaction and you begin by procuring the transaction maybe for a rights issue, only to realize that you have not procured the legal counsel or even the support professional to support that particular transaction. So that speaks to the need to ensure efficiency and, of course, the proper scheduling of assignments or projects. It's also the need to embrace innovation in rendering services. And of course, you see that if you cannot improve, then chances are that tomorrow your services may be of no use, or maybe they'll be too archaic to make any impact on your organization. So there's need to embrace innovation. And I think we'll be speaking to that some time back in some other slides. There's also the aspect of the need to delegate of tasks based on available resources, commitment by staff, and skill set available in the department. Work within the approved corporate procedures, processes, and structures. If not there, please ensure and support their development and implementation. Also ensure to procure and have in place an efficient, quality, reliable, and affordable panel of legal and related service providers. And always ensure to enlist their services when needed to complement your services. On this particular point, one of the critical things is that sometimes you find that as an in-house counsel, in the name of cutting costs, you really want to do assignments which are so many and perhaps even more complicated than the skills you have, and you forget that the reason as to why you have a panel of legal service providers is for them to come in and to deliver on such. So the issue is that you need to know when to stop as an in-house counsel and also when to outsource services to complement what you can do. Otherwise, as an in-house counsel, you may be bogged with so much that you cannot be able to do everything together, or maybe the complexities of the assignment require an external help. So it's very important to create that balance between what you can do and what calls for external intervention. The other thing is, of course, to establish a respectful working relationship with your service providers, with clear measures of accountability through service legal agreements, engagement letters, and regular communication and expectations for effective service delivery. I will not speak so much to that. It's also the need to have independence and fair good judgment in decision making. And as an in-house counsel, one should not give in to pressure and the reprisals from business leaders. This is very, it's a very typical issue, whereby perhaps because you want favors or you don't want to be gotten out of a particular assignment, or because you just want to ensure then that you're seen as the good person, you want to do things which perhaps you've not been able to get independence and interrogate. It is very important to ensure then that you do not only do assignments for fear of pressure or reprisals, but you do them because they are the right thing to do. The other thing is, of course, the need to drive corporate success and profitability and do what we call cost reduction. And of course, we need to see a case whereby a legal department needs to be seen as moving from a cost center to cost reduction and income generation department. I won't emphasize on that. I think the two doctors have already mentioned on that. Then a very critical thing is that the quality of legal services will be equated to the quality of the hire and the quality of the staff, and of course the right attitude, and of course putting in place a team which is motivated, has a culture of excellence and teamwork, and of course collegiality, collective responsibility in performance. Collegiality is ability to being able to, accept responsibilities on behalf of your colleagues, and of course, being able to step in for them when need arises. There's also need for constant regular staff training and awareness. And this can be done through weekly or monthly newsletters, bulletins, articles, and legal awarenesses, which can be conducted yearly. This is very critical because it speaks to the role and the relevance of legal, and then it seeks to show the value the legal department has for the business as a whole. It's also the need to avoid working in silo and to ensure that you hear out the other professionals. There's a gentleman by the name Alex, formerly a general counsel at GO, observed that there's a huge benefit to thinking like a lawyer. We are taught to evaluate the strengths and weaknesses of our position, but also to respect and hear out the other side. But this over specialization that characterizes the legal profession preclude a recognition of what other disciplines can bring to the table in terms of complementary skill sets and ideas. Do we need to look more closely at what a lawyer is not to understand and allow those who understand lead on the same? A big answer to this is yes. And it speaks to counsels who are actually working in highly complex environment. Ideally, look at an environment like the engineering environment, an environment dealing with things like roads construction, and an environment which deals with things like finance, whereby you are supposed to step back and on technical things, you need to listen to the technical people so that then they can give solutions to the table. So basically what I'm saying is that as a lawyer, you're actually not, you're expected to give a hearing to your colleagues in the other professions so that then on matters which fall squarely on their professions, they are able to speak about the same and then deliver value. That is not to say that you should not understand the specific area they have specialized in. But just like the need to respect your profession, it's also important for you to understand the other profession. And that calls for reciprocity. And of course, the respect we are looking at, if at all, you're also going to be respected in your respective field. Often associated with this presentation is actually the benefits of versatility and dynamism to both in-house counsel and organization. So what benefits are associated with
Sorry,
this?
Ibrahim, sorry for interrupting you. We are running out of time. If you could summarize your comments so the other speakers can, thank you.
Yes. So just run through the benefits of versatility. And of course, one of them is that when one focuses in general counsel, the word general in the word counsel, it means then that you're able to do as much differently from just being a lawyer, and you are likely to move into leadership positions. I think we have just seen Dr. Moria, who moved from a lower rank to where he is right now. And there are several people to speak about, especially in the Kenyan context. The other thing is, of course, it enables an in-house counsel to be able to easily transition from a purely legal role to a regulatory, human resource, procurement, audit, governance, and so many other areas, even all the way to a managing director. Then, of course, with the emerging competition, then one prepares himself to beat the competition in the legal field. It also enables one to do what he knows or likes best, creating career flexibilities and assuming an active role in areas like governance, legal audit, and compliance matters. It's also increased competitive advantage for the organization. It's capacity building and knowledge creation in other organization functions. Then, of course, legal challenges are never in a straitjacket, and as such, this diversity of skills is very important to offer what one can call an effective, better solution to legal issues. Then there's also strategic delivery and business thinking. And then very important is that it gives one what we call an organizational presence on taking a seat at the table of decision making. So that's basically my presentation, and I'll be open to questions at the opportune time. Thank you, Gloria, and thank you for according me the opportunity to undertake this presentation.
Thank you, Ibrahim, so much for your detailed insights. And we're looking forward to receiving all this material so we can always, refer back to it. If I may encourage our next speakers, Emily will be coming up shortly. to keep our comments very brief because we are running out of time and would like to also have the Q&A session. So kindly let's keep our comments down to 5 minutes as originally communicated. Thank you. Emily, please proceed.
Thank you very much, Gloria. Can you hear me?
Yes, loud and clear. We can hear you.
Oh, fantastic. Just with the times, I'll briefly put on my phone. I'm actually using my phone. I am at the industrial area in Matuga. For those who are in Uganda, they know where that is. So I'm actually sitting in my car whilst I do this presentation. So I will not be basically sharing anything on the PowerPoint. I'm going to speak through a few points. I'm just trying to see whether I can actually access my video so you can see me briefly before I remove it so that I can be able, so you can see me, I'm sitting in my car. So I'm going to carry out the presentation, the video. So if you can allow me to proceed. The question that I was given was also about versatility, and my colleague Ibrahim has actually said quite a number of things with regard to this subject. I worked in private practice, in-house for about 20 years in the financial services sector. And after that, I decided to pivot and go back to private practice where I had started. And one of the things that we have heard basically about versatility and for us as in-house lawyers is that we do have options available to us, either to remain in-house or you can actually go out and follow your dream. You can go to the bench. As you've heard, you can actually be a CEO. There are other options and avenues available because we also do risk management. So you can actually go and work in compliance, you can work in the regulatory sector. So we have actually quite a number of options available to us as legal practitioners. So at the end of the day, the question is how, and this is something that has been going through and that's read through the conversations we've had today, about have we grown our presence? Are we known out there so that we are able to be given these opportunities when they become available? Briefly, just to say that in my case, even as I work now in the private practice, I would say that it's very important because I'm still serving clients. Initially as in-house client, in-house legal, I had one client. I had one client, but with various departments. And when I try to tell people that, and I think I had Justice Kiyabwire talk about this, you actually end up finding that you have, you're required to opine over quite a number of different areas, a wide range of practice areas. In my case, for example, there was business, there was human resources, there was finance, global markets, CEO's office and strategic issues, operations, and input into procedures and manuals, risk, regulatory, concerning the regulator, the board, because I was company secretary, and marketing and PR, because also they had information that was going out. So there was a requirement for my input into the information or whatever documentation was going out into the market. So you can definitely see that as in-house counsel, you actually have a huge ambit of support for your clients. Even when you come outside from doing this, apologies, I was talking to somebody here. When you come outside, you're still going to be doing this same type of work for the different numbers of clients. So how do you develop your knowledge and your expertise around these areas? How then do you get to understand how best to look at always the business aspect? How do you do the business aspect? And I had Mr. Ibrahim talk about, of course, don't do illegal stuff. One of the things that we are there for is, yes, appreciate the business. But as you appreciate the business, you going to add? What is your addition? How have you improved the product so that once it goes out, or if it's a campaign, once it goes out, there are not going to be any issues that are going to come back to the institution. So in-house people, in-house counsel normally have a perspective that is ideally, usually lacking in private practice. You understand how to handle internal politics. You know what is going on within the different departments. You have information generally about the behind the scenes, what products, what has been made a priority, what is the strategy. This is information that normally once you get onto the outside, that is not easily available to you. Even as counsel, external counsel, and you're handling a matter for a client, they are not necessarily going to give you their strategy for that particular year. They'll probably give you information that is specifically useful for whatever matter you'll be handling for them. So most times you'll find that the information that you have is never as good as that for in-house counsel. So as external counsel, one of the things that we also have to do, minus just saying that in-house counsel are actually reaching out to us, we also have to reach out to in-house counsel so that we get to understand what is actually happening in the organization as we prepare. I keep telling some of my colleagues that one of the things that I managed to grow and become good at was strategy. And I had to do this because I realized when I was a young lawyer, it was not one of those things that easily came to me. Because I was constantly in the CEO's office. I needed to be able to have discussions with him on strategy. And I worked under 4 different CEOs. So definitely, it's one of those things where you had to be adaptable, you had to be agile, you had to be basically on top of your feet. So how then do you also grow to make sure that when you're having this discussion with the CEO, that you're adding value as a trusted advisor? So those are some of the things, and I think we've already had a chat about that. I'm just trying to see from my notes. Yes. We have to continue learning. Learning doesn't stop. As lawyers, thankfully, people say and they believe that we love reading. So continuous learning is something that is important in our field of practice. We have to suck it up when we find information or areas where we are not, we're not very well conversant. If you know you're going for a meeting and there's something where you're not very conversant, find out, get somebody who is good at this subject and find out what it is that they're actually talking about, because then you're going to need to do the advisory. So when you do the advisory, how will you be able to advise properly on an item on which you have no information? That's why, again, if I quote a few friends of mine, that's why they tease us learned friends. You find the information, get to understand, and then you're able to advise. So let us be humble, and we continue learning. Our attitude is definitely very important in how we handle such issues and how we handle changes in what is happening in the business. I used to work in a fast-paced industry. And the business was always coming up with things. One day they will come up with a product. We put in information, we put in a lot of work, and we spend like, in a month, we basically sat with them and worked with them and had a discussion. And then guess what? A few days later, they come back and say, we have changed. We are not doing that anymore. And you can imagine what that how that makes you feel, that you've actually spent so much time and input, and all of a sudden the business is telling you we are changing. We are no longer doing that particular project. We are not running with that project. So flexibility, adaptability is very important because you run with the business. When I was in-house, yes, there was a lot of flattery, being wooed by either the external counsel and even my so-called clients, because there are those who wanted to come to me. When I signed off on something, it was good to go. That was a green light. So yes, definitely there were always people trying to woo me and get my signature. So I had to be careful on what I signed off on. If people came at 5 o'clock or 7 o'clock when I was working late, and I am being told that this is an extremely urgent matter, I had to find ways on how to handle such issues, not to annoy my clients, and also to make sure that I'm able to buy myself time to review some of those issues that come at strange hours when I am pretty fresh. So as in-house counsel, have that at the back of your mind that yes, sometimes some of our colleagues might come looking for your signature. You have that pressure of trying to be seen as someone who is actually helpful and collaborating with the business, and in effect, you're actually being made to sign off things that are wrong. So always make sure that you actually read what you are signing. It's very important. Same thing that happens on the external side. So a lot of the skills that you're actually using right now are skills that you're going to be able to use when you come on the outside, because you're still going to be dealing with clients, except that the clients will be more than the one client you're currently handling at this moment. Just basically to conclude, I don't want to repeat quite a lot of the things that other people have said. When you work in-house, you're always justifying your budget, you're always justifying your position, you have to justify your growth in case you want to increase your department. You've got to sit down and also work on the financials and determine and say, this is why I actually need one more extra person. This is why I need growth of the department. You have to show your value, and therefore it's very important for any of us who work in a business to be able to understand the financials. I used to have a budget, and with that budget I needed to be able to prove as to why I either needed more money and why that money should not be cut. I was very lucky that I had learned how to read my budget. I used to go and get help from finance and be able to put forward a position where I needed to increase the department, or to be able to show that actually that work will be better done externally, and to be able to put forward information and figures that show why it will be a lot more efficient if done elsewhere. So that information is very important and gives you some kind of buy-in when you're talking, especially to your CEO. So my last words would probably be that be intentional on who you are, be intentional where you want to go and on what you want to do and what you want to achieve. I think I'll hand over back to the presenters. I'll be ready for any questions that might come from this session. Thank you.
Thank you very much, Emily. Thank you for your insights from the perspective of an in-house lawyer, external lawyer who was formerly an in-house lawyer. I will invite Hope to present the last three set of speakers, who will be talking about, the first two will be talking about the power of the blind spot. That is, how do our weaknesses impact our work? And the last speaker, who is currently an external lawyer, will be talking about the private legal practitioner's view on the in-house lawyers. Hope, please proceed. Thank you.
Thank you, Gloria. And I do recognize that time is not our best ally, so I'll give very brief introductions about our next speakers. We have Miss Julie Kapuki Lado, who is the head of legal compliance and company secretary, EcoBank, South Sudan. Julie has worked with the bank for close to 9 years. She holds an executive MBA from the Eastern and Southern Management Institute, Arusha, Tanzania, an LLB from Makerere University, and also a postgraduate diploma in legal practice from the Law Development Center. Julie, marhab, welcome. Alongside Julie is Ms. Sharon Mazimaka, the General Manager, Corporate Services and Company Secretary, MTN Rwanda Sale. Sharon has been with MTN Rwanda Sale since 2009, holding various positions. Previously, she served as General Manager, Legal and Regulatory Affairs, and Legal Officer and Legal and Regulatory Supervisor. She has an LLB with distinction and an LLM from the Wits University in Johannesburg. And our final presenter is Mr. Shehzad Awali, a partner at Stallion Attorneys in Tanzania, and who is also the chairman of Consciousness for Humanity, Utu Kwanza. He's an advocate of the High Court in Tanzania and mainland and Zanzibar. He's a CADA accredited and also serves as a mediator at the Ismail Conciliation and Arbitration Board. He's a law graduate from Tumaini University, Dar es Salaam, and holds a postgraduate diploma from the Law School of Tanzania, and has been in practice for over 10 years. He specializes in dispute resolution, intellectual property, investment, and real estate law. Ladies and gentlemen, you're welcome for this last session. And to start us off, we'll go to Ms. Sharon Mazimaka.
Thank you very much. Good afternoon to all. Very mindful of the time, so I'll jump right in it. I was asked to discuss, as mentioned, the impact of our weaknesses as in-house lawyers. And I think under the general topic of creating our visibility and influencing effectively, this is very important because there's no way as in-house lawyers we can influence without some self-awareness and self-reflection. So in the few minutes I have, I wanted to discuss really two sides of one coin, where as in-house lawyers, we can either be seen to be too isolated from the business of the companies we work in, or too integrated in the companies that we work in to allow us to be really effective in our role. So first, usually as in-house lawyers, when we join, we are very fixed on the fact that we're here to guide the company what they can and cannot do. And while that is important in our role, if taken to the extreme end, we end up with this reputation that we all know of being the buzzkill of the operation, of being an obstacle to operations. And the impact of this is that, for me, I feel is twofold. One, for yourself as an in-house lawyer, you miss the opportunity of truly understanding the business of the company you're working in. If you continue to isolate yourself, you limit your growth in knowledge in other areas. And we've seen with some of our colleagues already spoken, expanding their knowledge has led them to roles such as CEOs outside of the profession specifically. So in keeping yourself isolated, you do miss out on this opportunity. And secondly, you also create a loss of trust among your colleagues. They know that whatever we take to Sharon, there'll be a no, and as Siobhan mentioned, no explanations, but we can't do this, the law says this. So that impact of the rigidity is that even in trying to support, we may not get the full information from our colleagues, who will tend to now start keeping some details away from us because they know we're just going to get a no. So they try to see, how do we manage this rigid person at her desk? And then you can't really serve as you should when you do not have the full information. You can't guide on advice, you can't guide on the documents needed if you don't have the trust of your colleagues to let you know exactly it is what they want to do. On the other side of this coin, for me, I believe, is that if you get too integrated into the business where you're really looking at how sometimes you may need to turn a blind eye to some issues in order to help the company achieve what they want to achieve, or also then you end up in almost a constant state of conflict between what you know you should be advising and how you also want to support the business in getting where they want to get. And I believe this internal conflict then comes off sometimes as indecisiveness. And in the role you have, you don't have the room to be seen as indecisive, because again, that leads to a lack of trust amongst your colleagues. They don't know what they're gonna get, or you don't seem sure because of this internal conflict that you're facing. So to me, I say it's good, important for us as in-house lawyers to recognize this, to acknowledge where we may go too far on either end of the spectrum and see how do we establish this middle ground. And for me, this middle ground, as has been mentioned by some of the speakers, is where we are seen truly as a trusted partner of the business, not just as a support, but a trusted partner to the companies in which we serve. And this looks like, to me, the middle ground I see is where we do not stray away from the law just to be yes men or to rubber stamp or make things go the way we think or the way we know our colleagues would like it to go. But at the same time, so we don't stray away from the law, we use it to find solutions. And where we cannot give the answer that our colleagues want to hear, we take the time to explain to them, take them through why not, that the regulation says ABC, and it says this to protect ABC, and tie into their role, whether they're in HR or in marketing or in finance, use the language to explain to them. So you're not only learning more about the business through their eyes, but they're also learning from you as an in-house lawyer on how to interpret and how to understand why you're saying no to particular issues. So it's not just a flat no. And I think thirdly, to establish this middle ground as a trusted partner, consistency is key. You need to be consistent in how you approach the different challenges and how you engage with your colleagues and how you show up every day so that they know, yes, maybe you'll be firm, but you will be fair. And they'll always get explanations and understanding of your position and why not, and then tying it into their role and their outcomes. So you end up in a position where you're engaging with them directly one-on-one. Okay, what is it that you want to do? And how can we do this within the realms of the law? So I think with that in mind, acknowledging our weaknesses, to summarize, recognizing them, knowing maybe some days you're on one side of the spectrum, other days you're on another, but really intentionally working to get in that position where you do take the time to be aware beyond your little bubble, but also bring people in your bubble to explain to them and guide to them. And I think there you can be truly established as a trusted partner in the company. And only then can you really have influence. Only then you can truly have influence on your company and be really seen as someone beyond just a support role. So I think that's it for me. I tried 5 minutes. I hope I made it. Thank you.
Thank you so much, Sharon. Taking from you, you're telling us basically guard against indecisiveness and establish a middle ground. Thank you so much. I invite Juliet to give us her remarks as well for the same topic. Juliet, please proceed.
Thank you so much. I'll just pick from where Sharon, can you hear me?
Yes, we can hear you. Please proceed.
I'll just pick from where Sharon stopped. Oftentimes, these weaknesses are not known to us, but when we go back to look at them, they really limit how we act, react, or behave, and actually limit also our belief. And therefore, we may not be able to positively impact our business. So these weaknesses can range from, are you too afraid to ask for help because you've been branded as the one who knows it all? Are you insensitive towards the business? For instance, do you recognize that your delay in one aspect or your delay in disbursing a certain loan will impact the business, will impact the revenues of the business? Do you have or do you avoid difficult conversations? When this colleague of yours walks to your desk, are you afraid to say no to a certain thing because you'll be branded as the one who limits or who is not in support of the business? Are there commitments that you don't follow through or you treat them casually? You're not there when the business needs you. The business cannot actually rely on you on certain aspects. Are you always the one blaming somebody else? Do you tolerate low standards? Or for instance, you'll say, okay, since my team member cannot do X, Y, Z, let me take it upon myself to do that. So for us to really become effective leaders, we need to recognize these blind spots. We need to recognize these areas of weaknesses that we may have, but we don't know of. So how do we do this? Look at the way you behave towards others. Look at how you make decisions. Look at how you share information. Do you delegate? Do you ask for help? Are you connected with your team? Not your team as the ones in the legal department, but the overall business. Are you connected with the head of HR, for instance, or head of production, depending on where you are? Do these people actually trust you? And the element of trust comes in, do you know your business? As all the panelists have mentioned, do you know your business? You cannot be in aviation and you only know the law, but you don't know what certain steps. You cannot be in banking. You limit yourself to knowing the law, but you don't know how these processes are made or what your colleagues go through. So you need to take a keen interest in knowing these things, the business. So it may be hard, fine, but there are certain steps that you can take as an individual to ensure that you get to know these weaknesses and then work upon them. One, self-awareness and willingness to learn. If you've been given feedback on a certain aspect or on a certain weakness that you may have, put in steps, put in measures on how you can turn these weaknesses into positives for yourself. For instance, if you cannot read the financials of your company, for example, and you have been advised that you need to read these financials and interpret them, go for a training in financials or in finance or non-finance managers. Take concrete effort. Let the business or let your CEO know that you're willing to learn some of these things. Solicit feedback. Don't be in your corner and you branded the I know it all. This feedback, not only from your colleagues, but go down to your team members, your team of 5. Ask maybe the most junior of them to give you feedback. And when this feedback is given to you, take it constructively. Work towards it. Look back and examine your past. Look at the aspects that made you succeed. Look at where you've struggled. How did you react in certain situations? When you look at this overall, it may be able to impact on how certain decisions that you make. Key also is having a partner out there, somebody you can on speed dial call and ask, okay, I have an issue here. How do you help me with this? I have this feedback. How do you work on this? So have this accountability partner who will guide you through some of these things. This person may be a mentor, or you go for coaching, somebody who has been there before, but you must have somebody you can speak to in order for you to grow. As mentioned, key for us as in-house lawyers, we're not only there to know the law, we are there to know the business and support the business. Not that everything, not as a rubber stamp, but when somebody comes up with something, you should be able to guide them and tell them that, okay, it can't be done as per the law, but we may find X, Y, Z. Find a creative way of doing things. Not that every time a document is brought to you, you say no, or you say yes. Creative ways. So we'll all recognize that it's an effort changing these weaknesses, flipping them to the other side. It's an effort which we must consistently work towards. I think I'm just under 5 minutes, but we must recognize these weaknesses and learn how to flip them around. Thank you so much.
Thank you so much, Juliet, for your insights on the weaknesses. I'm sure we've all taken notes. And for me, what stands out the most is take measures to work on areas of feedback, because then that's the only way we grow. Thank you so much, Juliet. I now invite our last speaker for this webinar, Shahzada. Kindly, please proceed.
Hi, everyone. This is Shahzada Wali. I have been requested to talk briefly on how we as the external lawyers can contribute towards the effectiveness of the in-house legal counsel. So I prepared just a one slide with a few pointers for you so that this could probably help you. So if we could have that slide. All right. So as external lawyers, this is something that we are expected to do, but also I would say as in-house lawyers, this is something that you should definitely put as your policy or to-do list for external lawyers. So for instance, the first and key thing is prompt and frequent feedback and updates. From my experience over the period of many years that we've been servicing clients with in-house lawyers and CEOs, that we have been sending weekly updates to our clients every Friday. And that's the day when our lawyers sit down and send the updates to all the clients that we have, which gives an indication to a client whether or not there is a new update or not, at least that their case or their assignment has been worked on. Number two, we need to really be cautious about the human resource and legal audits. This is something that is very key. And from time to time, you need to engage your external lawyers to sort of come in and review your contracts, your pending HR works, etc., so that the external lawyers can give you a feedback or some sort of an opinion on how the company is doing, and what are the statuses of some of the contracts. Maybe they need to be improved, maybe they need to be changed. So that's something that external lawyers can do and should do. Time to time, legal opinions. This is something that I always insist upon my clients, especially the in-house lawyers, that no matter how small the matter is, reach out to me and ask me for a legal opinion. Send an email, dear so and so, we are engaging into business with another company. What do you think should be the do's and don'ts? What is the checklist? We have a contract. Can you please share your opinion? We have a demand notice. Can you please help us out? So legal opinions frequently requests are good, and that will really help you also be able to be answerable to your CEOs or managing directors or shareholders, etc. That look, our external lawyers have provided these legal opinions, and we think this should be done. Updates on the laws affecting their industry. A lot of external lawyers tend to do this from time to time, but it's always a good idea to have it in your checklist, to email your external lawyers and say, dear so and so, kindly provide us with any new updates on our industry, or we have this particular update on the laws affecting our industry. Please, can you shed more light? There are also some usual things going on in every country. Immigration laws are changing, financial laws are changing. So always keep asking them. The other thing that I think external lawyers can contribute towards the effectiveness of in-house lawyers is having bi-weekly or monthly reviews of tasks, assignments, and cases. These days, during COVID and now I would say not exactly post-COVID, but post the lockdowns, etc. We can see that we're having so many Zoom calls and team calls. That way, even if you don't have to meet in one room, set up a Teams call or a Zoom call with your external lawyers and say, look, can we just go over all the cases and assignments that you're handling? And that would give you a better understanding on what is required, or anything that particularly is burning issue that can be resolved immediately. Lastly, I would say that it's important to have performance review meetings. We, as Stallion, actually encourage our clients to meet our practice managers, but also from time to time, we like to have performance review meetings just to check in to say, how are we doing? Tell us, So again, that's something that you could do as well by contacting your external lawyers and saying, look, you've been servicing us for maybe years or months. We want to meet you and give you feedback on how you're performing. Or sometimes as partners, we want to know, how is a particular lawyer at our firm performing? So you can set up a call or a meeting and say, so-and-so lawyer in the firm or has not been handling our matter in the correct way. And that way, the partners at the firm, the practice manager at the firm is more aware of what's happening. To be very honest, if there's one thing as an in-house lawyer you should definitely do is keep in touch with the external lawyers from time to time. They should be on your weekly checklist or task list to have a call with, have a meeting with, and especially the partners at the firm. There is this notion or a myth that partners at the firm are very busy. I have to be very honest with you. They're probably the less busiest because a lot of the heavy lifting is being done by the associates. And so it's much more easier to reach them actually. You know, set up a coffee, a lunch, a drink, you know, with the partner to share your frustrations and your concerns. And trust me, you'll get a lot of insight from the partner. So get rid of that myth or notion that the partners at the firm are the busiest. They're definitely not. And I can share this from my experience. I'm always willing to meet and talk to the in-house counsels around. So, you know, communication, feedback, and update. That's something that would really take you along. Otherwise, I feel like this topic could have taken even an hour or two. But in a nutshell, that's what I could share from my experiences. However, you can reach me at any point in time to basically ask more questions, etc. I'll post my contact on the link. I saw a question pop up on how people could contact me. So I'll definitely answer to that. So thank you to the hosts for giving me the opportunity to share. And thank you to the other panelists for sharing what they did. Sante.
Thank you so much, Wally. I kind of feel like you've given me something to work on my terms of reference when it comes to external lawyers. So I'll keep that list in mind. Thank you so much. So we want to quickly run to the Q&A. I will reach out to Hope. If we have any Q&A, any questions burning questions that people would like to ask the panelists, could we take them now before we close the session? I am quite aware that we have run over our time, but I do not want to do so without addressing the questions. Hope, do we have any questions or comments from the comment section?
Thank you, Gloria. And I want to thank the panelists for their insightful presentations this afternoon. I think they were very spot on. We probably have more compliments than the questions. In the chat, I see one question that is not yet answered. But just to clarify that there were questions that were for Dr. Shivon Biamukama, and she did answer them through the Q&A chat and the main chat group before she went off the call. So those questions were answered. But we have a number of compliments, and I'd like to read out a few. Most of the panelists, most of the attendees are thanking the panelists for their presentations. George Okello says the need to be deliberate in learning about the business cannot be overstated. We also have compliments for Dr. Moria and Justice Geoffrey Chiawire about their presentations. We have Johanna Mukua, brilliant session. Kindly let me know if I can have Justice Chiawire's presentation. I think Gloria will give a comment about that. Harriet Magala, very insightful and informative presentations from Dr. Moria and Honorable Justice Chiawire. Thank you. We have a comment from Grace Akulu, not Akulo, sorry. I had always thought being an in-house lawyer is a misplacement, but I have got courage through the presentations and pray that in-house lawyers network to consult and retool. Barbara Doris Nabaka says, thank you, Honorable Justice Chiawire, for that great mentorship, especially for me who is in the insurance industry, currently in Uganda. A very insightful question that we have is what happens where an organization refuses to take up your legal advice or opinion and they end up in trouble? And I will probably give that to Ibrahim if he's still with us, because I think he spoke lightly about that. And we have one person with a hand up for a question. I will ask our IT team to unmute her, and that is Hajat Sebiada. Please unmute her so that she can ask her question because her hand is raised. IT team, can you please unmute Hajat Sebiada so she can ask her question?
Thank you very much, Hope and team. This is Hajat Sebiala. I sit on some boards, but I'm also the president of Women in Insurance in Uganda. I have quick questions. Number one, what is the maximum number of external lawyers that an institution should have? And it so happens that with some external lawyers, every interaction is charged. I don't know what advice you give about that, because we've been advised that the external lawyer should, be engaged as much as possible by the internal lawyer. But it so happens for some external lawyers, every engagement is charged, is a cost. So we need to know how many and what advice you give. The last one is about institutions that by their law, the CEO is the secretary to the board. And they so tag the legal, they don't even have a legal department, but the legal person who is there is so low in the hierarchy. So I don't know how you advise such an institution to handle these internal legal or board issues. I thank you very much, and it has been very nice being on this call. Thank you.
Thank you, Hajat, for your questions. You should probably have told us a little more about yourself. Hajat is not a lawyer, but she's an eminent woman in Uganda, and very, very well respected in the insurance fraternity. Thank you, Hajat, for your questions. Hajat's questions on must external lawyers charge for every engagement? I think I'll let Mr. Wali answer that. And on I'll probably ask Sharon to take that on. And then what's the maximum number of external lawyers an institution should have? Again, let me ask Wali to answer that. But first, let's start with Ibrahim.
Okay, thank you, Gloria. My question was on what's the fate of an an in-house counsel, whereby it gives an opinion, but then the same is not taken into regard by the organization. My answer will be that accountability for an in-house counsel is limited to his or her participation in the decision making or the opinion he gives. So for that particular reason, if I assume that today I gave an opinion to my organization on a particular issue, and for one reason or another, that opinion is not taken into consideration in making a decision, then of course, in terms of accountability, as an in-house counsel, one would not be expected to account for whatever sanction or adverse decision taken against the organization, perhaps by example, a regulator, or maybe even in a court of law. For reasons that you are available, you did not abdicate your duty by not giving an opinion. You actually gave an opinion or an advice, but for reasons perhaps not known, the opinion was not taken into consideration. So that would be my answer to that particular question.
Thank you, Ibrahim. Over to you, Mr. Wali, on the two questions that...
Hope, can I just add on
yes,
to that
yes. Do you
question before Mr. Wali comes on? This is Emily.
Okay, yes, Emily, go right ahead.
Yes, in case the circumstances do happen from time to time, and they say there are issues where management, or they decide, at the end of the day, that probably your argument was not strong enough, and they decide to take a particular decision, which turns out to be wrong. The first thing you do as in-house counsel, when yes, you can quietly be happy, because that means next time most likely they will listen to you a little bit more and take you more seriously. But you have to own, because remember, when this decision is taken as management, you are part of management. So you have to own the loss together with management. But the good thing usually that comes out of such activities is that next time when you speak, you will be given better audience. That's what I wanted to add.
Thank you, Emily. Thank you, Emily. Let's go straight to Mr. Wali for the 2 questions.
So Hope, please, can you just clarify the first question? What actually was the first question? I know the second one was on the number of external lawyers.
The first question is, must external lawyers charge for every engagement? You were encouraging engagement between the in-house and external. Must you charge for every engagement?
So you see, any external lawyer on your panel should be considered as a legal partner. So when I talk to my clients, I always call myself a legal partner. And when you're a legal partner, you're external lawyer, as an external lawyer, you're not supposed to be charging for every single advice or opinion. I think you also owe a duty to your client to support your client in their business and see that the business grows. As I think Justice Kirabire mentioned that, they actually ended up having a law firm within their company because they wanted to manage the budget. So as an external lawyer, you also ought to sort of help the company grow in their financial goals. And in doing so, as an external lawyer, you're not supposed to be charging every single advice or opinion. And this is what I normally encourage my clients to do is, look, you can reach out to me for any advice or legal opinion you want. And as long as it's not an extensive opinion and it's something that can be responded to by email or by a call or by a meeting, I think that's fine. So no, you're not supposed to be charged for every single advice or opinion, unless it's something very complicated and the firm feels like this is an opinion that needs to be charged for. In the second question as to how many external lawyers you should be having on your panel. So number one, it really depends on how big your company is and what are the reasons you want external lawyers to be there for. So if you do have a very big corporate organization that needs 10 external lawyers because you feel like you have corporate cases, you have human labor cases, you have, I don't know, banking cases, and you definitely want to have a check and balance. So you may have about 5 to 6, probably on your panel. But if you're a mid-sized company or a growing company, then you may want to have 2 to 3 on your panel. But again, that really goes with what is the need of the company. So I'd say really make an assessment on, does your company need more than one external lawyer? But definitely it's good to have at least 2 on your panel. I would say a minimum of 2 external lawyers if you're a big corporate. I know banks, for a bank, at least have 4 on your panel, so that you can, always also have a healthy competition. Because again, when an external lawyer knows that there are 3 other on the panel, they sort of, pull up their socks and try to do better to get more jobs from you. But I think anything more than 5 or 6 on your panel is really a waste, because you might not end up using them. So minimum 2 is good, but at least 1 should be there, and maximum 4 to 5 to maintain your financial position as well, because you have a budget to maintain. Thank you. I hope I answered your question well, Hajat.
Thank you, Mr. Wali. That is the external lawyer's perspective, but perhaps we can have an in-house lawyer. Julie, do you want to comment on that? Just 30 seconds. How many external lawyers should you have? on your panel, or Ibrahim, whoever is available, just 30 seconds. We have heard from Mr. Wali's perspective as an external lawyer.
Okay, Hope. Firstly, I'll say that there are no hard and fast rules in terms of how many you can have. But then for me, the rule is that have as much, but as little as the work requires. And this calls for a case of the needs, the number being determined by one, the work or how busy your organization is in terms of legal needs. Second is, of course, the complexities of the assignment. And of course, the other critical thing is that in terms of the in-house counsel staffing, how staffed is the legal department? So that I'm looking at a case whereby if the legal department has only one staff, then definitely we expect the number to be the number of external counsels to be a little bit big. But if you have a legal department with external counsels like 10 for complex or large organizations, especially in the public sector, then of course you will not expect to have such a big number. So yes, the number is determined by various factors. That means the work volumes. Second, the staffing in-house, how it is. Then of course the complexity of the assignment. But an important thing to have is, of course, don't have big numbers which you are not able to service, because you'll be attracting a case whereby you have people who have been in the panel, but then you've not been engaging them, which is also not good, morally speaking. It's good to have a number which you can keep busy, and of course, whereby you can be able to confirm that you've been utilizing them for the period you've engaged them. That would be my my response to that particular question.
Thank you for your comments on that, Ibrahim. Very insightful indeed. And I think, like you said, there are no hard and fast rules, but you've provided some guidance therein. So our final question is, which I will now direct to Emily, Miss Emily Gakisa. The CEO is also the secretary to the board, but the legal person in the entity is low in the hierarchy. So what advice would you give in such a situation? Over to you, Emily.
All right, thank you, Hope, and thanks to Madam Hajat Sebiala for raising that. I don't know whether the other countries in East Africa have that anomaly, but it's one that we seem to have here in Uganda for parastatals and NGOs. And it's unfortunate that some parastatals have seen fit to have the executive director or the CEO as the company secretary, and the NGO sector for that, most of them, they have the CEO or the executive director as a company secretary. Definitely, it means that a lot of the roles that are required of the company secretary are not met. Visibility of the legal department is not good. So what then happens is that, unfortunately, the organization hires junior people, and that definitely impacts on the visibility and the standing of the legal department. And I do believe that is something we need to start pushing to ensure that that changes, because it means that a lot of those organizations do not hire legal counsel at the appropriate level. And even you as a lawyer, if you went to work in such an organization and find out that you're not necessarily being used at your optimum level and you're not being given a seat at the table, most likely, most times you find yourself leaving. So I think for me, that is unfortunately a creature of statute that we need to work as lawyers to change. When we're given opportunities to review the laws when they come for our review, we should have that input going so that we can have that specific section amended, and we have appropriate governance oversight and have those roles split. That would be my comment. Thank you.
Emily, and I think those are the only questions we had. I hope you've all received feedback in one way or another. Yes.
Hope I can give a comment on that particular question as well from the Kenyan context.
Okay.
Yeah,
Okay.
actually the scenario is also not so different from Kenya for some organizations, not all of organizations. Actually, the scenario is that in Kenya, most organizations have the position of the company secretary profiled at the senior management level. That means functionally reporting to the accounting officer or the CEO, and of course directly to the board. But then we have scenarios, especially with some organization, and I think I can mention some, especially the various boards within the road sector, whereby, like our colleague has just said, the positioning of the position of the company secretary is below the general managers. So that means you are like tier 3. And of course, for obvious reasons that the statute recognizes the CEO as the secretary to the board. I'll mention, like I said, especially in the road sector, the parastatals within the road sector. So yes, a similar scenario prevails in Kenya, but not for many organizations, for some. And of course, it calls for that kind of intervention, if at all, of course, this particular role of the company secretary is going to play a strategic role, and of course, claim that kind of seat at the key decision making, and the clout required in terms of advisory in strategic decisions.
Thank you. Thank you, Ibrahim, for your comments. I think time is not our best ally. That is all we can take for today. So I will hand you back to Gloria.
Thank you so much, Hope, for taking us through the Q&A. Maybe just to respond to the question on presentations, this will be emailed to you as always, and the webinar will also be shared on YouTube. So you'll have all the information that you require for this webinar. I would like to conclude this webinar by extending gratitude to all of our speakers today, both those who are still on the call and those who had to jump off the call, for taking the time to be with us and sharing your knowledge. I know it's not always easy to get ready for these webinars, but you have provided so much insight and a lot of things for us to chew on for, I think, for the foreseeable week. I also want to thank the listeners who have stayed with us from the beginning to the end. Thank you so much for making this an interactive session, and for all the various questions and the comments that you have provided. I hope you'll continue to let us know what areas you'd like to be trained on. Please leave your comments before you drop off, or give your responses in the survey. I can't leave the webinar without giving gratitude to the East African Law Society that has presented this opportunity. Thank you so much, and to many more of these. Hope, my lovely co-host, thank you so much for making this a flawless interaction. I would not do this without you. And from me, it's a goodbye, and see you next time. Bye.